Next one is qualification of an attorney. According to Contract Act, major, sound mind and not disqualified persons are competent to enter into contract as attorney. But it is the duty of the principal to appoint a reasonable person as attorney, who should act with utmost good faith. An attorney is a person who has been appointed by the donor to act on his behalf. An ideal attorney is that who must be willing to act in that capacity, and he has to be impartial, having integrity. An attorney should be loyal to the principal and should not disclose any confidential matters related to the business. Next point is very important, that is legal powers which can be granted to the attorney. Broadly speaking, a power of attorney provides an attorney all powers that the principal has to manage the principal's financial affairs or make health care decisions may be enough for many purposes. An attorney may be authorized to execute all contracts, deed, bonds, mortgage, notes, checks, etc. To manage or comprises, settle and adjust all the matters uh, regarding real estate, to lease, collect rent, grant, bargaining, etc., to sell any and all shares of the stock bonds, to file, sign all taxes returns, to enter into contract and to perform any contract, agreement, writing or thing to make, sign, execute, deliver, knowledge, acknowledge any contract agreement, to make healthcare decision for the donor or his for the donor, the principal, or his or her minor children, to sue to sue on behalf of the principal. So it is very important to identify or to indicate the powers of attorney, because only the powers which is specified in the power of attorney can do those acts. An attorney can do those acts and he will be responsible only for those acts, not without that specified acts, or he will not be able to do anything which is not specified in his power of attorney document. This is a format of power of attorney. First you have to maintain the rules regarding non-operative part of power of attorney, and the first part is description of the instrument or name of the instrument. Here the name or description of the instrument is power of attorney. Then the party's name. Here I mentioned A as principal and B as an attorney, and you have to put all the details of A and B, like son of, age, NID, profession, residence. Same as for B, son, age, NID, profession, residence. It is very important for power of attorney to include being of sound mind and legal capacity, do hereby appoint. That means he is a competent person. Principal is a competent person to enter into a contract with an attorney. That's why he mentioned here that he is sound-minded, he is major and not disqualified by law. And the next one is, as my true and lawful attorney, in fact, to act for me in my name, place, and on behalf to do and perform the following. That means here he confirmed that what is the contract between principal and attorney. Next part is operative part. As you know, operative part, it is the terms and condition of a power of attorney. On the other hand, you can explain it as the duties of an attorney, or you can also say that all the duties which principal uh, for which principal appoints attorney for serving that duties. So you have to start with the following property, interest and rights shall be subject to this power of attorney, and then you have to write all the duties according to the wish of the principal. It is obvious. If there is any immovable property, that means if there is any property, land, anything, then schedule of the property is mandatory. As you know that for any immovable property, schedule of property is essential part for an instrument or for a legal document. And for 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 further fraud or for any security, for further security, please don't give such power which depends on the discretionary power of the attorney. So don't write anything that it depends on the discretionary power of the attorney, or it depends on the discretionary power, whatever attorney likes, he can do that, because that can create another problem. So please try to write specifically what the duties according to the wish of the principal. Next, you have to write down the time, or you have to specify the period when it will revoked, or when it will be revoked by the principal. That's why I mentioned here this power of attorney shall be effective on the, you have to put the date when it will start. The power of attorney shall remain in the effect of the event that I should become or be declared disabled, incapacitated, or incompetent. If you think it will be declared, then it will be, otherwise you can change it. The power of attorney shall terminate on the, obviously you have to put a date, unless I have revoked it sooner. So you can put the date also, and you can write there that whenever I want to revoke, or whenever principal wants to revoke, he can. I may revoke this power of attorney at any time and in any manner. Then any attorney shall be paid compensation for services according to this power of attorney as follows. Identify compensation attorney will receive, if any. If you want to give any type of remuneration or any type of compensation, whatever duties attorney serves for that purpose, you can write down here. Next, this power of attorney shall be governed by the laws of Bangladesh, and in witness whereof I signed this power of attorney of my own free will, executed this on. You already put one date in the in the power of attorney. This power of attorney shall be effected on. So whatever date you put there, you have to put here, or the same date here also. So this is the starting of formal part. This is the starting of formal part of the power of attorney. In witness whereof I have signed this power of attorney of my own free will, that means nobody influenced him, executed this on the date, whatever you want to put here. This is also the formal part of power of attorney. You have to put principal's signature, date, principal's name, and then put attorney's signature, date, and attorney's name. And before that, you have to put agreed to and accepted by. Obviously, attorney agreed and accepted by. And then in the presence of the undersigned witnesses, at least 2 witnesses are necessary. So witness 1, name, address, signature of the witness. Witness 2, name, address, and signature of the witness. This is the last part for power of attorney. It is an acknowledgement. It is a mandatory part for power of attorney. According to the power of attorney rules 2015, without acknowledgement, the power of attorney will not be executed. So this is an acknowledged part. This document was acknowledged before me on this something day by principal's full name, who is personally known to me, or who has provided in the form of passport of or an ID. You can provide passport number, or you can provide an ID number. Then you will put the signature of the advocate, and that's why I'm writing here signature of notary public. Notary public is a seal, you know, red color seal. So obviously you put the signature, or advocate will put the signature, and he will put his signature and the seal also with his full name and address. And for this purpose, please remember, acknowledgement. Why acknowledgement is necessary? Acknowledgement or notary's role or acknowledgement's role for a power of attorney document is to witnesses and confirm the identity of the person signing the form. So advocate of a notary public will confirm, yes, there are two witnesses and it is confirmed the identity of the person signing the form. The notary is certifying that the person who signed the form did so in the notary's presence, and it is confirmed that this is the person who is the principal and this is the person who is the attorney, and the principal appoint attorney for specific duties or for specific purposes. For this purpose, you have to remember there are another types of power of attorney, that is joint power of attorney. For joint power of attorney, you have to change few things and rest of the format will remain same. Few things means, number one, you have to put the two attorneys name and their details. Here I put only one name, that is B. You have to put two attorneys name and their details. And next one is explain and include all the duties of the attorneys. They can they can act jointly or can act severally, but you should include all the terms or all the duties clearly and in detailed manner for their proper understanding, so that both attorney can understand whatever they want, they need to do according to this power of attorney or according to the wish of the principal. And last one is you have to put both attorney's signature, date and name. Both attorney's signature, date and name. So that's all for power of attorney. Please practice in your home and try to write a joint power of attorney. Thank you. That's all for today. Hopefully, very soon we will meet by Google Classroom as consultation hour. If you have any questions, please feel free to ask me on Google Classroom as consultation hour.